This is foreclosure attorney Elliot Schlissel. Today I'm going to talk to you about how New York State has made it much harder for banks to be successful in mortgage foreclosures. Mortgage foreclosure lawsuits in the state of New York usually benefited the banks and the banks' lawyers. A new statute in New York has made it much more difficult for banks to be successful. Foreclosure defense lawyers like me have a new sword to strike back at the banks. You see, financial institutions have in the past had 6 years from the time the mortgage was accelerated to bring a foreclosure case. The acceleration of the mortgage starts when the bank calls the entire mortgage due and owing. In the event the financial institution and their lawyers did not move forward with the foreclosure within 6 years of the acceleration of the mortgage, the case could be dismissed for violation of the statute of limitations. The statute of limitations is a complete defense in the state of New York. The violation of the statute of limitations simply makes mortgages unenforceable. When a lender brings a foreclosure lawsuit and then for one reason or another it discontinues or stops the lawsuit from going forward, they would, in the past, take action called decelerating the mortgage. This means they would want to start the foreclosure statute of limitations period running all over again. With regard to this, the state of New York passed a Foreclosure Abuse Prevention Act, and this stops banks from doing anything to extend that 6-year statute of limitation. Except in very unusual circumstances, a bank has 6 years from the initiation of a lawsuit or from the acceleration of the mortgage to start a foreclosure lawsuit and be successful. This is foreclosure defense lawyer Elliot Schlissel signing off.